An assured tenancy is a legal category of residential tenancy to an individual in English land law that can be contrasted to a tenancy beyond 7 years and affords by statute a degree of security of tenure to the tenant. A tenant under an assured tenancy may not be evicted without a reasonable ground in the Housing Act 1988 and, where periodic, changes in rent are potentially subject to a challenge before a rent assessment committee. Assured tenancies were introduced by the Housing Act 1988 that applies to tenancies entered from its commencement date or those assured tenancies it converted from the Housing Act 1980. The Act replaced most of the greater rent protection under the Rent Act 1977 and in rarer cases, other rent acts. However, since February 28, 1997, all new residential tenancies with 3 exceptions are deemed to be assured shorthold tenancies. These exceptions are those excluded by notice before or after the tenancy, those specifying it is not a shorthold, and lettings to existing assured tenants. Non-assured tenancies, tenancies entered into before the commencement of the 1988 Act on January 15, 1989. An exception to this are assured tenancies which are converted from being regulated by the Housing Act 1980. And on January 15, 1989 the 1980 Act tenancy is continuing by virtue of that section or of any provision of Part 4 of the said Act of 1954. Tenancies not of a separate dwelling house, this counterintuitive term, dwelling house, applies to exclude only businesses and highly indistinct subdivisions of houses or flats such as where shared in no particular set of joint tenants can be said to be entitled to the whole. Flats and single rooms are included within the definition of a separate dwelling house as are converted barns, windmills etc. High-value properties, because domestic rates were abolished, a distinction exists between tenancies granted before April 1, 1990 and those from that date. Before this, a dwelling house tenancy with a rateable value of £750 cannot be an assured tenancy. From this date, if the rent is more than £100,000 per year, it cannot be an assured tenancy. Tenancies at a low rent, similar for those tenancies before that date, if rent is less than 2/3 of the rateable value, or if after that date it does not exceed £250 per year, it cannot be an assured tenancy. Tenancies for agriculture, agricultural holdings, persons with temporary protection, under arrangements made for asylum seekers and their dependents, and family intervention tenancies. These detailed areas include a tenancy under which agricultural land, exceeding 2 acres, is let together with the dwelling house. Business tenancies, to be exact, this excludes tenancies to which Part 2 of the Landlord and Tenant Act 1954 applies. Tenancies eligible to be protected business tenancies or partly let for business use are ineligible to be assured tenancies. Educational body lettings to students, this does not apply to tenancies involving landlords other than the specified universities and colleges. Holiday lettings, a letting for this purpose cannot be assured. By live-in landlords, this applies where the landlord lives in another part of the same building in which the let accommodation is situated. Crown, local authority and housing association lettings, although these are excluded, lettings by local authorities and housing association may have other protections, such as secure tenants under the Housing Act 1985. In occupation as the principal home of the tenant, it is possible for a person to have more than one home, in which case it is a legal question of fact as to whether a home is the principal home. Although this provision stipulates occupation, this need not be continuous. If a mere temporary absence, this will still be capable of being an assured tenancy. If and so long as, whether a tenancy is assured can vary depending on circumstances after the tenancy commencement. It may be that the tenant has not by eviction ceased to live in a tenancy, in which case they are no longer occupying the dwelling as their principal home. Here the tenant thus loses security of tenure. Security of tenure operates in a slightly different way depending on whether the tenancy is a periodic or fixed-term tenancy. If the tenancy is periodic, it will only come to an end either by an order of the court or by surrender by the tenant. If the tenancy is a fixed-term tenancy, it may be ended either by the effluxion of time automatically expiring, with no need to serve any notice, at the end of the fixed term, or, if the tenancy agreement gives the landlord a power to end the tenancy, by the landlord exercising that power. If a fixed-term assured tenancy comes to an end in one of these ways but occupation continues, known as holding over, a periodic assured tenancy will from that event be created, known as a statutory periodic tenancy. Security of tenure remains. In order to regain possession, the landlord may do so only on one of a number of statutory grounds, which are set out in Schedule 2 of the Housing Act 1988. To obtain an order for possession, the landlord must serve a Section 8 notice on the tenant, setting out the ground or grounds that are relied on, and then, after a period of time that varies depending on the grounds chosen, appellee to the court for possession. Unlawful eviction of a tenant is a criminal offence unless the landlord reasonably believed the tenant was no longer in the premises, is sharing living accommodation with the tenant, or is letting the property for holiday purposes. Increases of rent without specific provision under an assured, periodic tenancy cannot be increased within 52 weeks of commencement, and unless a statutory periodic tenancy, this may only be increased upon the service of a Section 13 notice in the appropriate form for England or for Wales. However, as with general contract law, a historic lease amendment or new lease neglecting such a notice before such an increase accepted by the tenant will be deemed to have supervened, preventing the tenant from relying on an earlier contract and not serving a Section 13 notice. Naturally, where fixed term and not periodic, and where a rent review clause exists in the periodic tenancy, contractual arrangements also avoid the need for the Section 13 notice. The Section 13 notice gives the right to the tenant to challenge the rent set under Section 14 before a rent assessment committee where it is unreasonable that the market would charge such a rent, disregarding improvements performed by the tenant to the property where they were not obliged to carry these out. Comparison with assured short-hold tenancies. From February 28, 1997, most tenancies are deemed to be assured short-hold tenancies under which the landlord has an absolute right to possession where, having served a notice on the tenant, before this date they had to be accompanied by a prescribed warning, fixed term, and for at least 6 months. The only potential disadvantage of a short-hold is the right of the tenant to refer the rent initially payable to a rent assessment committee. However, it can reduce the rent only if it is significantly higher than the rents under other comparable assured shortholds. In this unusual scenario, the landlord can serve a notice before or after the tenancy has begun stating it is not to be a shorthold, where no rent assessment application has been made. In other regards, except security of tenure, as a subset of assured tenancies, these follow the definition requirements of an assured tenancies. See also, assured short-hold tenancy, short assured tenancy, English land law, rent regulation in England and Wales. Notes. References.